Amarav Kahana Amarav Cheresh Sheyachol Ledaber Mitoch Eksav. If a deaf mute, Cheresh really is a deaf, but a deaf mute is unable to speak either, is able to communicate in writing. So I'm going to say the name of Rav Kosvin Venosin Get Lishtar. He's able to write. He may write a note saying to give a get to his wife. So actually, this case is it doesn't tell you, but it's talking about a deaf mute who originally was not deaf and mute, who got married as a regular with all his faculties and senses, and then during the time he was married, he became a deaf mute. Yeah. So now the question is, when he got married, it was a marriage midiraisa, and a deaf mute, if he got married, originally would just be midrabanan. So he was saying, so usually a deaf mute, because the wedding is midrabanan, they can't communicate properly. So therefore, the get usually would be deaf mute would have been midrabanan, yes. So their get also being midrabanan, so they could get a divorce. But now they have a case where the person had all his senses beforehand, and so his wedding was midiraisa. So now he's getting divorced. He can't no longer speak, so it would look like midirabanan. So it's a big problem, because midirabanan doesn't equal for midiraisa in terms of getting a get. So what Rav is telling you, that he can show that he has enough of his facilities, faculties, that he could still get communicating in writing would be good enough to get even divorce according to midiraisa if he writes it down, because the writing actually shows that he has that he's capable of doing it. So then the Gemara is going to ask a question. Amar Rav Yosef, Ma Ka Mashmalan. Why? What is Rav teaching us? Why is he teaching this to us? Tanina, we've already learned in our own Mishnah. If you recall, the Mishnah says, Nishtatek, if a man became mute, he's unable to speak. Amru lo nichtav get lishtacha, and they said to him, shall we write a get for your wife? The hirkin barosho, and he nodded his head yes. Botkin also shlosha pamim, and they test him three different ways. Imamar al love, and if he said no where he's no, he's supposed to say no. V'al hey nein, and he answered yes where he's supposed to say yes. Hare elu yichtavu v'yitnu. They can write a get and give it to him. So now, if a mute person can demonstrate his competence by gesturing, as our Mishnah says, then a deaf mute, which can presumably do it by writing, because writing is even more choshev way of showing the person has his faculties about him. So why was it necessary for Rav to come up with a ruling? We could have learned it out just from a person who was unable to speak. So the Gemara answers, Omar le Rav Zera. Raizel said, Eila ka'amart. It says, did you mention one who is only mute? You were talking about, the Mishnah is talking about a mute person. You're talking about a deaf mute. And those are two different things, because a mute person, Shani Elaim. A mute person is different than a deaf mute. A mute man is usually mentally competent, but the Rabbanan hold that if a person is both deaf and mute, that this person was unable to learn properly during his childhood or whatever, and therefore that usually they don't have all their faculties about them. So if it's good enough that for a person who's mute may write and give his get if he gestures for them to do so, because he's usually competent. How would you know that a deaf mute person could do something even writing? And also, as I said, it's complicated because it's midiraisa and the original marriage, and now it's midrabanan. So therefore, Rav had to tell you about a deaf mute person. So he's considered mentally competent enough that if he writes something, then therefore he would be considered good. Because otherwise, would have thought that normally that a cherish, that a person who is both deaf and mute, is not considered competent, and therefore he would not even accept it if it was written. Tanya was taught in the Brisa, someone who can speak but cannot hear, that's the person who's called a cherish. Someone who can hear but cannot speak, he's called an elaim. And both this cherish and that elaim are considered mentally competent for all their affairs. It's only when someone is both unable to speak and unable to hear, that person is not called mentally competent. But from where can it be derived that a person who can speak but cannot hear is called a cherish? And that a person who can hear but cannot speak is called an elaim. You get it learned off from a posuk. For it's written in Tehillim, but I, like a deaf man, a cherish, I do not hear, and like a mute person, who opens not his mouth. So you learn from there that the elaim is a mute and the cherish is a person who cannot hear. Or if you want to say, as people commonly say when referring to a mute person, ish takel milule. His speech, his speech was taken from him. So now they're going to ask a question on Rav's ruling that a person who's cherish is able to get by writing. Rav Zera said, if I have a difficulty with Rav's ruling, the following is my difficulty. The Tanya is learned in the Brisa. Im lo yagid, the Torah says, if he does not tell, parat l'ilem she'ena yochel yagid. So what we're talking about is do not tell is a person appears to court and is asked to testify regarding, I guess it's a money matter, or actually any matter, and they ask him to say, and he says, I don't know anything. So such a person, if he does that, and then they find out that he was didn't say anything that was untrue, but he did know the facts and he didn't say it. He says that he's chayiv for chatas. It says parat. But this excludes a mute witness who they ask the same question to, and he doesn't answer that he knows anything. He does not chayiv for chatas because it says because he can't talk. Yochel could not talk. But why should he be exempt if Rav is correct? It says, he could just write down. Why did the Torah exempt a person who's not able to speak? Because presumably it's because he can't testify, and he has to testify, and he can't speak. But let him write. We said writing is such a good way of showing that a person is competent, and for giving testimony for a get. It's accepted for a get to designate somebody else. So why, if he testifies, why can't he testify in writing? And because he has ability to testify in writing, then he should also be chayiv v'chatas if he doesn't answer when he's asked to testify. Omar le'Abaya answers edus ka'amrat. You're speaking of testimony. She'eni edus, the law of testimony are different than the laws of divorce. The Rachmana Omar mipeim v'lo mipi kusasam, because it says what it's talking about. Giving testimony, it says, is that from their mouths, which implies that only from their mouths can they testify, but they can't do writing. Otherwise, you'd be right, that he should be chayiv. But since he didn't, but since it said specifically, but he has to testify by his mouth, so therefore he's potter if he doesn't testify or even write. So Mesaveh, they asked a question on this. Just as we test a mute man's competence concerning divorce, Kach Bodkin also, so we test his competence Masaos, Umatonos, Uleedios, Lerushos, concerning business transaction, gifts, testimonies, and inheritance. So we said before that a person can't give any edus if he can't speak. But now we have a brisa that says even somebody who gives edus can. The Katoni has edus. The brisa taught edus. So this contradicts by assertion that a mute person can't testify. Omar Rav Yosef bar Manyume, Omar Rav Sheshes, Be'edus Isha. The brisa, it says you're right. If normally what it's talking about, it does say a person who's giving edus can testify, but it's talking about a particular case. What's it talking about? Be'edus Isha. The brisa is referring to a testimony concerning the death of a woman's husband. Ta'kilu ba rabbanon, where the rabbis were lenient, and then even one witness, even a woman, is accepted to give testimony for it. Therefore, when this Bryce is talking about that, we accept their testimony for For a mute person, it's talking about in this type of case. Therefore, they're leaning on it. The Hoktani Rishus, but the Brisa also taught about Yerushas, that he may testify about another person's Yerusha. So there he's testifying there. How can he do that? So Amar Rabbi Abayo is Yerusha's Benoah Bechor. He's not talking about somebody else. He's talking about his own Beno, his own Bechor, his own situation, and that he wants to alter his firstborn son's share of the inheritance. That normally we know the firstborn son gets double share, but it's up to they can change that. And that's what he was testifying for, and that's why he's believed, because he's just talking about himself. And that's why the writing, normally a person have to be able to speak if he's testifying against others. But Raizel also taught concerning business transactions and gifts, and about presumably for other people, and that he's testifying. He can testify. My love Lama, does a Brisa not refer to a mute man testifying about the sale of a gift to a third party? It says lo lidide. No, it's talking about his own. That he's about his own gifts that he wants to give, and therefore he can decide whatever he wants to do. He's not really giving edus about it. So now they're going to bring another question about Rav. Mesave, they challenge Rav from a Brisa Cheirish concerning a deaf mute. Loi hachu bo acher lemi zosa v'achar kifi sosa v'achar kasov yadoi. They accepted his gestures and his lip movements and his ability to communicate in writing as proof of competence. Element taltalin, only for transactions involving movable items. Avolo legittin, but not for gittin. Rav said that a person who's mute, and we said earlier in the Brisa also that a mute person can do by gestures. But they're talking about only writing, so they're only talking about Rav who said that certainly writing is good for a cheirish, and it's certainly good for a mute person. We know it has more competence than a cheirish, than a deaf mute person. And it says here that a deaf mute person is not for get. It cannot write permission to give a get, and he said that we could. So this goes against Rav. Says Tanoihi. So Rav's ruling is that actually they're telling you Tanoihi. It's a matter of a Tanoic dispute, and Rav holds one way according to one Tana, and another Tana says differently. The Tanya was taught in a Brisa. Amar Rabbi Shimon ben Gamliel. When do these words of this Brisa apply? That he can't write that a cheirish can't write a get. Becheirish mikor, the one who is originally deaf and mute. Because even if such a person can communicate in writing, we do not consider him competent with regard to gittin laws. So in other words, he was saying he's originally deaf, so he's never competent. So how can we therefore accept his writing? But if he was competent originally and then became deaf mute, who koisev, he may write a get. Vehein chosmin, and others may sign on it. So Rabbi Shimon ben Gamliel is saying, provides the basis for Rav's ruling that if a deaf mute can communicate in writing, he's authorized to divorce his wife, as we said originally. He says, but in the beginning of this Brisa it says becheirish mikra lo. Now, a person who's originally deaf and mute, he says, is can't. If he was like that originally, then we don't accept his ability to divorce his wife. And he says, but that's not what we learned in our Mishnah. We said, Kishem shekonsa birmizah, just as a deaf mute marries a woman through gesturing. That's what we said in that Brisa they brought out. Kach motzia birmizah, so he may divorce her through gesturing. So he just finished saying, when he's quoting it, Rabbi Shimon ben Gamliel, that if he was originally deaf and mute, then he could not divorce him. So we know from somewhere else that that's not correct. So it says, this doesn't apply. Rabbi Shimon ben Gamliel is not talking about if Rabbi Gamliel's Brisa concerned a deaf mute's wife. This person would also apply in this case. But what are we talking about? The case concerning his Yavama. So what we're talking about is that a deaf mute is married. No, sorry, his brother, the deaf mute's brother, is married, and he died without children. So now the Yivam falls to the deaf mute person, and in order to do the Yibum, all that's necessary is to have Bia with the wife, with the widow, and it doesn't require any real competence in terms of thinking, and so therefore the Yibam marriage is considered from Deraisa. Since the Yibam marriage was biblically recognized, so therefore was talking about, and he said before that a deaf mute, when he brought down a Deraisa, that if a person was deaf mute before he got married, he can't get a divorce. He wasn't talking about a regular case, a regular marriage. He's talking about where the person had a Yibam. The deaf mute person had yivum, and therefore, since it's a midrash of the wedding, and a cherish can only get divorced through midrabanan, so therefore he cannot get divorced, and that's what Rabbi Shimon Gamliel was talking about when he spoke about it earlier, that they could not get divorced. Yavidim Aman, his yivama that was widowed. Who was it widowed from? If you say that she fell to him because his brother was a deaf mute, say that just as her first marriage took effect through gesturing, so if his brother was only married to his wife, the one who passed away was only married to his wife through a rabbinic marriage, wasn't a midrash marriage, so therefore he would have the same limitations on him. So it came to Yitzhak ben Misa, so he would also be able to divorce her through gesturing. So Ella only the naflale melchas mikpeich. Rather, Rav Shimon Gamliel referred to a case when she fell to the deaf mute from his competent brother. So this is what I was talking about. The case was that his brother was competent, and he had a marriage, and then he died, and then they got married. Then the Yibam fell to the cherish, and now the cherish's wedding is through midraisa, and because he can only give a divorce through midrabanan, therefore he has no, even by gesturing, it's not considered a divorce. Or, if you want to give another answer, actually, Rabbi Shimon Gamliel is discussing a case where she fell. His brother, who had died, was a cherish. And then normally you'd be able to give a divorce, but in this case, it made a gezerah that for a deaf mute brother, because of possibility that she might be confused with a case where she, and therefore, if it came from a deaf mute brother, she could be confused, and then you allow him to get a divorce because it's only a midrabanan, that it would confuse that case when his brother actually was not a deaf mute, was not a cherish, and it fell to him for a divorce, and then in that case he could not get divorced. Then so people would think, oh, I remember that two brothers and that the guy was able to get a divorce for it, even though he's mute. So let's do it in this case, whereas the brother was not the one who passed away, was not cherish, and so they confused it. So they made a gezerah that he cannot get divorced. If so, the rabbis ought to have decreed concerning his own wife too. If you're not going to allow him to get a divorce when he's allowed to get a divorce because you're worried that other people think in a case where a competent person's wife will come out and will make a mistake. So say the same thing too. When he divorces his wife, when he's a cherish, because he originally was a cherish before, and they're going to confuse with a case where he wasn't, and now he's allowed to do it. So why do you allow it to do it for his own wife? This is his yavama that fell from his competent brother might be confused with his yavama that fell from a deaf mute brother, a cherish. But ishta b'minta lo mech. His wife, however, would not be confused with his yavama because everyone knows that he was always a cherish right from the beginning. And then now we're going back and asking. So now you said the reason why that you don't consider that he's allowed to divorce his yivam when his brother was cherish to begin with because of Xera. He says, is that really true? Do we really decree that a deaf mute may not divorce a yavama that fell from a cherish brother because of the possibility that it'd be confused when his brother is not a cherish? And the case happens. This is Hatanan. We learned in the Mishnah Shnei Achin Cheshen Nisuin. Shtei Achoyos, because if two cherish brothers were married to two competent sisters, or shtei achoyos chashos, or two deaf-mute sisters cherish who were married to, or they're married to two deaf-mute sisters, or shtei achoyos achas mikachas v'achas chereshes, or that the two brothers, the cherish brothers, were married to two sisters, one who was competent and one was cherish. V'chein shtei achoyos cheshus. So too, if two deaf-mute sisters who cherish sisters nesuas lishnei achin pichin were married to two competent brothers, or lishnei achin cherishin, or to two deaf mute brothers, to cherish, or lishnei achin echad pikeach echad cherish, or they were married to two brothers, one who was a cherish and one who was not. Hare elu b'toros min hachalitza umin habibim. All of these cases are exempted if the brothers died childless from Yibum. Why? Because we're talking about two sisters, and two sisters, as we learned before when we did Yivomis, are not, they're Erevas, so you can't marry one brother, we can't marry the other one. But Im Hoyu Nachriyus, but if these two sisters were not related to each other, Yichnusu, the surviving brothers, should marry the widows with Yibum. The Imratzu Latzina, if they wish to divorce him, Yotzia, they may divorce him. So, we're talking about whether the one of them was competent, whether one was not competent, it didn't really matter. They said they allowed them to divorce him. Before we said they made a gezerah that if you had, you're not going to allow a non-competent or non-cherish, you're not going to allow the cherish brothers yivum to get divorced because of the possibility of the brother who was not a cherish. So this shows that you can. So it says Ella. It says you're right. Ella mecharfata d'shana mikura. Therefore, the original answer that we gave originally was correct. Is that a man who is originally deaf and mute lacks authority only to divorce the yavama that fell because of that a deaf mute person can't divorce because of gestures or writing. Sorry, what was the original one? A man who was originally deaf and mute lacks authority only to divorce Yivama that fell from a competent. The Rabbi Shimon's answer originally was that the reason why we said that when the Brisa said that a cherish can't get divorced by gesturing, it was talking about a special case where the wife came to him from Yivam, and because it was midaraisa, and therefore we don't let him get divorced because he can only do a divorce through Rabbanan. So Amar Rabbi Yochanan says, Chalukin Olav Chavera al Rabban Shimon Gamliel. And Rabbi Yochanan said that Rabban Shimon Gamliel actually disagreed with him. What it was talking about here is that, what is Rabbi Yochanan saying? We just finished saying that there was an argument between the Tanoim. Rabbi Shimon Gamliel held one way, and the other held another way. But what Rabbi Yochanan said, that actually you could work it out that Rabbi Shimon Gamliel really was not arguing with the different Tanoim. He was just only explaining what case we were talking about, and in that case he actually agrees with him. But Rabbi Yochanan is coming to tell you that Rabbi Shimon Gamliel actually disagreed with him. Omar Baya. And we can see that he actually disagreed with them from here. Af anan nami tanina. We have also learned this in the Mishnah. Nishtes, the woman became deranged, lost her competence mentally. Lo yotzi, she cannot divorce her husband. Nischareshu or nishtata. If a husband became cherish, lo yotzi alamas. He may never divorce his wife forever. My alamas. What does it mean? Never. Lav af al gav diyochel adaber mitachak. So it does not mean that even if a deaf mute can communicate in writing, he still cannot divorce his wife. So that shows that this Tanya is going against Rabbi Shimon Gamliel, and therefore he's arguing with him. So they said, no, or maybe not. Papa, E loved the Ashmuni and Rabbi Yochanan. If Rabbi Yochanan had not informed us that Rabbi Shimon Gamliel was actually having a disagreement with him, I could have given an answer, again, like we made up before, why this case was different than the other case. And whereas if this case would have been different, he would have been agreed with him. So Havamina, I would have thought that Rabbi Shimon Gamliel, La Purshe Taima the Tanakama Huda, so Rabbi Shimon Gamliel came only to explain the Tanakama's thinking, explaining what they really meant, and not to dispute with it. Umay alamis, and what does it mean when it says never? Because this goes against what Rabbi Shimon Gamliel says. It says you can, at least by writing. He says, why does it say you never get divorced? he could just write it down and give him a divorce. So if Rabbi Shimon Gamliel could still support this, that even though, what does he mean by never then? It means that even if we see a deaf mute who's sharp, we consider him incompetent. In other words, you see it's a person who's cherish, but you can see he's answering questions and so forth, and so he knows what he's talking about. Therefore, you would think that maybe you would accept this type of person for to give a divorce. So the Bryce that just quoted says no, that type of person can never get divorced. However, if he is able to write, and he can show that he has the faculties to be able to write, which requires a higher level of competence, then we would accept it. So therefore, he could make up a scenario where Rabbi Shimon Gamliel would agree to that brisa, or inami to Rabbi Yitzchak, or alternatively you can say that this is applying the rule of Rabbi Yitzchak. Rabbi Yitzchak, the devar Torah shota misgareshes. Under biblical law, a chorish can be divorced midei dehava pi kachas bal korcha, because she is comparable to a competent woman who's being divorced against her will. Uma tam omru eina miskareshes, and what is the reason then that the rabbi said he can't be divorced? We said that even through gesturing, whatever. Shelo yisagu ba minhag hefker. So they figure the person is not competent. Then and she's now on the street, and people are going to take advantage of her. So therefore, they said if your wife, if the person got married and his wife became deranged, therefore he's not allowed to divorce her forever. It's not because he's not capable of the cherish to divorce. It's just out of seamless for his wife in order to be able to make sure that she's going to be protected. That was the easy part. So now we're coming to the harder part. The Mishnah. Amar lo nichtav ged li'ishtacha. A person said to a man, a person is not able to communicate, and he says to him, I think we're talking about, just a moment. I was just talking about it could be anybody. Could be anybody. They're asking. He's going on a trip. He's very ill, and so they ask the person, giving him suggestion. It says, "Amar lo lichtav get li'ishtacha." Should we write a get for your wife? Amar lahen, and he says, "Kesovo, write." Amru l'sofer kasei. So the people who had asked him that went and told a sofer to write a get. V'la'edim nechosmu, and for edim to sign it. Afal pi shekasuvu chasumu v'nasunu lo. And all those, although these people wrote it and signed it, and then gave it to the man, v'chozer l'sonu lo, and he in turn gave it to his wife. Hare get bottle. We don't consider this get good. It's a bottle. It's no good. Ad shiomar, unless he says l'sofer kasom lo edim. For a get is not. It's saying a get is not would not be considered valid unless the husband says personally to the sofer, write, and to the witness, sign. And what they actually said to him, shall we write a get? And he only said write. Didn't say talk about signing or anything else. So the Gemara. So why was the in the first case where he said write? Why is that not good enough? Taima delo amar titnu. The reason why it validates the get is because the husband did not say give the get. Rather, he only instructed to write it. But had he told the agents only give the get, and the agents got a sofer and witnesses, noslin, they would have been authorized to write and give the get for him. Money, yeah. Whose opinion does this Mishnah reflect? Rabbi Meir here. Because Rabbi Meir, da Omar Mile Mim Suran L'Shliach, who said that words can be transferred to an agent to pass along to another agent. We learned this much earlier in the GITTEN, that the Rabbi Meir maintains that since people commonly appoint others to issue orders for them, these people are considered actual agents of the person who wants to get. And whenever a husband tells three people, they're talking about here that there are three people to give a get, he presumably designates them as a court, and therefore he empowers them to act as agents and tells others to write the get. And So we're saying that the reason why it wasn't accepted in this case is because he didn't tell him to give the get, and that's an important part of it. He only told him to write it, and that would be according to Rabbi Meir. But Ema Seifa. But let's look at the Seifa. The get is void, it says in the Sefer, unless the husband himself says to the sofer, write, and to the witnesses, sign. This implies that only the sofer and the witness appointed by the husband are empowered to write and sign a get, and he can't give this over to a shliach. Asanan le Rabbi Yossi, and this follows Rabbi Yossi. Remember, Rabbi Yossi said that a person cannot empower another person to write a get, or to give a get, or to sign a get. Only the husband himself has to do that. So it looks like the end of the Mishnah going according to Rabbi Yossi. So Rabbi Meir, v'Sefer Rabbi Yossi. So it looks like it didn't attribute it to them, but it looks like that's the way it's written, that they have two different people saying the Mishnah. So this is the Gemara answers, yeah, you're right. Ein Reisha Rabbi, yes, Reisha Rabbi Meir, v'Sefer Rabbi Yossi, and Sefer Rabbi Yossi. Okay, that's one answer. Abaye Amar, and it says Kula Rabbi Meir here. It's all going according to Rabbi Meir. And what are we talking about here? Delo Amar Tnu, in which case, with a case in which the husband did not say give the get, rather he told the agents to write it as well. If he had told them simply to give the get in the end, if he had told him to give the get, then he would, that would have been fine. So this would go according to Rabbi Meir. If so, the Mishnah should have stated that the get is void unless the husband says, "Give a get to my wife." So the reason why it wasn't a good get at the beginning is only because he mixed giving the get. Did not say actually give the get, but had he said, and they were trying to prove that the last part is going according to Rabbi Meir also. He says the reason why he says in the first part is because he didn't give a get, and the reason why he says in the last part at the end that he did do it because he did say that. So so he should have said that was the reason why that Rabbi Meir was saying that if Rabbi Meir is giving both the first, the Reisha, and the Seifa is Rabbi Meir's opinion, then at the end it shouldn't have just said that he had to say specifically if he told him to write the get and give the get, it would be good. All he had to say that the get is void unless the husband says, give a get to my wife, and that would have been good enough. Why did it require the husband personally appoint as in the last part, the sofer and the witnesses? It wouldn't be necessary. Rather, what at the end of the Mishnah of the case we're dealing with, the case of the husband did not talk to three people. We said before that the reason the Rabbi Meir only holds that a person can give a get is with if people can designate other people to act as a shliach is only if he's given it to three people. But if there aren't three people there, then they wouldn't be empowered in order to pass on the ability to other people to write the get, and they would have to do it themselves. So what is he talking about? The end of the Mishnah, we're talking about with a case where the husband did not speak to three people, but rather the two. Since even Rabbi Meir agrees that two agents cannot be empowered to appoint a scribe and witnesses, and that's why at the end of the Mishnah says that the husband has to say, write the get and sign the get, because they're no longer talking about a court, the Beis Din, and therefore didn't have the authority to give it to anybody else, and that's why the Mishnah at the end says that he has to say that. But if there had been three of them, then the Mishnah would have said that yes, no, that it wouldn't have to say that they need to get a sofer, but all he would have had to say at the end, and it would have been worded differently, and it says he just has to get somebody to actually give over the get. If so, the Mishnah should have stated that the get is void. At the end, why does it talk about the situation to go say something, go say to the person personally by the husband to write the get and sign the get? All it had to say at the end is the first part is talking about three, and the second case is the get is void unless the husband speaks to three people, and if he had three people, they can designate or delegate it, and if he does less than two, there isn't. So therefore, that answer doesn't work. Ela kula Rabbi Yossi. So rather, let's say the whole Mishnah is not like Rabbi Meir at all. Let's say it's all going according to Rabbi Yossi. And here at the beginning of the Mishnah, what case are we dealing? Delor Amar Imru, with a case in which a husband did not explicitly tell the agents to tell others to write the get. That is why the agents cannot designate others to do the get. In a case where the husband explicitly told agents to appoint a scribe or witnesses, however, the Mishnah agrees with Rabbi Yossi that they can do so. So Rabbi Yossi holds that the agents can't appoint others to give a get, but they can tell others to write a get. So when it says that in the beginning of the part, it says he did not explicitly tell the agents to give the get, and you must because a person cannot designate other people to give the get. You can only, according to the way we're understanding it now, that Rabbi Yossi says you can appoint people to write, but because the husband did not appoint a person to give the get, therefore in the beginning part of the Mishnah it says that get is no good. So therefore, the whole Mishnah be going according to Rabbi Yossi. We saw before that the end does, and now we just proved that Rabbi Yossi can be the person who said at the beginning as well. If so, the end of the Mishnah should have said, just the get is void unless a husband explicitly tells the agent to tell others to write the get. Then why did it go into the saying, instead of, it said in the end that husband must tell the person to write and tell the person to sign? It's just leave that all out. Just tell that the get is void, as it is in the first part of the Mishnah, unless he tells at the end that the husband has specifically say, give the get. Not the way it was written. It says that the husband has to say, write the get. But it's still more. Me more de Rabbi Yossi ka'omer imru. Does Rabbi Yossi in fact concede that in the case where the husband told agents to tell others to write a get, and the agents do so, then the get is valid? We never. Where did we get this from before? All we said before is that Rabbi Yossi held that a person cannot designate. How do we know that he can designate, that it's okay for a person to designate for a person to give the get, and we're talking about, when he says he can't designate, he's only talking about writing and signing the get. Well, Tanan, but this cannot be, for we learned in the Mishnah, Kesov Sofer ve'et kosher, a get that contains the writing of the scribe and a signature of a witness is valid. Now, if you remember again, this is going back to something we learned previously, that if a sofer signs on a get, he's considered as a kosher aid, and all you need is one more aid along with it. Omar Rabbi Yirmiyah and Rabbi Spitz, concerning that case, Chasam Sofer Shanina, we learned that the writing of the scribe refers to the scribe's signature as a witness. Omar Rav Chisda, and Chisda said, Masinima, and whose Tanu's opinion is reflected in our Mishnah? Rabbi Yossi, it's Rabbi Yossi. Omar Milei Lo Mimur L'Shliach, who says that mere words of instructions cannot be transferred to an agent to pass along to another agent. So in that case, Rav Chisda maintains the Mishnah's ruling reflects Rabbi Yossi's view, and Rabbi Meir, however, surely does not subscribe to the ruling, because according to him, it could have the following disastrous result. Rabbi, this is what we just said, that a signature of a sofer is good. So we're bringing the proof from the fact that we said that. We learned in the Mishnah that the writing of a sofer and the signature of a witness are valid together, and we're going to try to prove that why is it valid? Is because we want to prove that Rabbi Yossi does not hold that a get can be written over, and it's developing his question that a get can, the delegation of one person to tell another person to give the get is no good as well. And how we're doing that is by saying that the fact that there's a Mishnah that Rabbi Yossi holds that a sofer can sign on a get. This the only reason why a sofer can sign on a get is because the sofer was designated specifically by Rabbi by the husband. If he wasn't designated specifically, there would be a case. And this is the case we're talking about according to Rabbi Meir, and Rabbi Meir does not hold that a person can designate a sofer to sign. A sofer is not good to sign on a get, because it'll be a case where the husband tells Yosef Omer Imr, the husband tells others to write a get. v'nofik mine churba, and even according to Rabbi Yossi, if a disaster could result from the Mishnah's ruling, which would allow when if a person allows the sofer to resign, for sometimes a husband will say to two agents, tell a scribe to write a get, and these two people must sign it. So he designated two other people to sign it, not the sofer. But the agents might be concerned about the scribe, the sofer, being insulted. I mean, he's such a chush of a person who can write the things, and now we're telling you, no, you're not good enough to sign it. The husband only asked me, and they will let the sofer sign it. And even though the husband never said that he may do so, he only gave the reshus to the agents. And therefore, it'll come about that now this whole wedding was, the divorce was no good, and then the wife had gotten married to somebody else, and they had children, and then everything, all sorts of problems from that, and therefore, so they made, according to Rabbi Meir, a sofer could never sign on a get, and if it's because cannot be delegated because they'd be worried at another time that a person delegated other Adam to do it, and there'll become a whole problem because he's designated these two and those two, and the sofer signed on it, and it would not be good. But Rabbi Yossi, that's because Rabbi Meir holds that you can designate under circumstances to other people. So therefore, that scenario could all come about, and therefore Rabbi Meir would never allow a sofer to sign a get. However, Rabbi Yossi holds that you can never delegate another person to sign, and if the sofer knows that, if someone came and asked him to write it, he would not be allowed to sign it. So if he did put a signature on it, you can trust that the sofer was told directly by the husband that he should be a signature on the get, and therefore we're going to see that when it says a get contains a writing of scribe and a signature of a witness is valid, we can see that Rabbi Yossi holds that you cannot give a get. So now I spoke it out, and I was just going to say inside Elam Mechavarta, rather it is evident that the correct interpretation of Mishnah, as we explained originally, Reisha Rabbi Meir, the Sefer Rabbi Yossi. The beginning is Rabbi Meir and Rabbi Yossi, because now we can't say that the Mishnah was talking about a case that all goes according to Rabbi Yossi, because we would say that Rabbi Yossi, and what we're trying to say before is Rabbi Yossi would say that as long as it's okay to give a get, that's why the first case was not good, because he didn't actually use the word get. So we just finished going through that it cannot come out according to Rabbi Yossi. It can't come out according to Rabbi Meir. The Sefer, the Reisha can't come according to Rabbi Yossi. Therefore, it must be both of it. And we'll stop here, and you'll get the final.